Good morning, good afternoon, and good evening. Thank you so much for joining us. I am Professor Dr. Luis Maria Palma, President of the International Association for Court Administration. Today, we are developing the fourth session of the online conference program jointly organized by IACA with the State Judicial Administration of Ukraine, the EU Project Pravo-Justice, and USAID Justice for All activity. This conference is dedicated to justice, digitalization, and information security management in war times and beyond. The topics to be covered by the distinguished experts who honor us with their participation are digital technologies in court administration to improve access to justice, security, and reduction of operational costs, remote justice in the context of the ongoing war, artificial intelligence and judicial systems, opportunities, benefits, and challenges. Please, Dr. Anna Adamska-Galan, key international expert on judicial reform of the EU Project Pravo-Justice.
Thank you very much, Dr. Palma, for the introduction and for giving me the word. I would like to welcome all our participants who joined us online on this next conference, which we have an honor and pleasure to organize together with the International Association of Court Administrators and also with colleagues from USAID Justice for All. The topic that we want to touch, that we want to raise today is extremely important. It's about digitalization of the judicial system, its importance, its impact, and also the risks that are connected. And Professor Palma already mentioned some of them, challenges and possibilities to ensure access for justice for all. This is also the issue of collecting evidence, and especially our colleagues from Ukraine are facing this challenge in the context of the ongoing war, where so much evidence is collected digitally, and there is also the issue of how to secure it. And also, I believe it will be very interesting to start a discussion about the artificial intelligence, which is getting stronger and more influential in the current world, and no doubt it will have also impact on this, how justice is being delivered. So sooner we start talking about this, about the risks connected with it, it's better, because we will be better prepared for dealing with these new challenges. I wish you all colleagues a very interesting and very fruitful meeting today. As always, as Uliana already said, we invite you to share your comments, to put questions, to share your thoughts in the chat. And it's always nice to read that there are so many colleagues from Ukraine and from all over the world who joined us today. Thank you very much, and all the best for you.
Thank you so much, Dr. Anna Adamska-Galan. Please, Mr. Serhiy Sushenko, legal advisor of the USAID Justice for All activity.
Thank you, Dr. Palma. I will switch into Ukrainian, if you don't mind. Шановні колеги, доброго дня. Дуже приємно всіх бачити. Я бачу багато знайомих облич.
Dear colleagues, it is my great pleasure to see everybody here. I can see many familiar faces. I can see many new faces. I do hope that our today's discussion will be of use, of practical use for all the participants. I'm sure that digitalization is a perfect instrument to make administration of justice more user-friendly and more convenient for all participants to court proceedings. I guess it is something which allows facilitate interaction between court users and the court as such. Besides, digitalization, as mentioned by Anna, allows a better collection of evidence, greater possibilities of storage of evidence, and is of help with many other activities. Thank you very much, and I wish us all good luck.
Thank you so much, Mr. Sushenko. Now I'll briefly describe the rules for the session. The online conference is being recorded. I'll introduce each speaker before the presentation. After all the presentations, there will be approximately 15 minutes for questions and answers. We'd appreciate if you could send us your questions using the chat box and identify the speaker to which they are addressed. We kindly request you to mute your microphones. Now we'll start with the subject, judicial technologies in court administration to improve access to justice, security, and reduction of operational costs. Please, Mr. Victoria Prokorenko, head of the ECITS Control Center of the Department of Information Technologies of the State Judicial Administration of Ukraine. The floor is yours.
Доброго дня. Прохоренко Вікторія, начальник.
Good afternoon. My name is Victoria Prokhorenko. I'm head of the UGITS Control Center of the Department of Information Technologies of the SJA of Ukraine. I would like to share with you information about the tools which are being used to facilitate administration of justice in wartime in Ukraine. So one of such tools is the electronic cabinet, which facilitates the registration of users in the UJITS, which stands for Unified Judicial Information and Telecommunication System. I will use further the abbreviation UJITS. So the electronic cabinet may be created within the UJITS. The identification of users is carried out by way of application of electronic digital signature, which is maybe issued either by the specialized state authority or by the Ministry for Digital Transformation. The users of the electronic cabinet include notaries, legal advisors, participants to proceedings, registrars, enterprises, individuals. So as you can see, there is a variety of users who have access to the electronic cabinet. Next slide, please. Next slide. Speaking of the second tool, which is actually the subsystem of the UJITS, there are and it is called electronic court. Currently, the subsystem. Can we go back, please? Yeah, yeah, it's good. So the electronic court, what the electronic court is, it is a subsystem which allows exchange of court documents among between the judge, legal advisors, not public prosecutors, and participants, parties to a case. The electronic court is available for the Supreme Court and appellate and the cassation courts, which are part of the Supreme Court of Ukraine, and two appellate courts. The electronic court subsystem is used to submit court documents by all participants to court proceedings. Evidence can be submitted via electronic courts, including audio and video files. Some payments can be done through the electronic court subsystem. Statements and applications can be submitted via the electronic court The electronic court also provides for the possibility to check whether other participants to a case have registered their electronic cabinets. The e-court also facilitates communication between court users and court employees and judges. The e-court provides for the possibility to issue powers of attorney, to check powers of persons who participate in court proceedings on behalf of legal entities and so on. Individuals, legal entities, and representatives and various public authorities can get registered in the electronic court subsystem, even without having the identification number, which is one of the requirements of Ukrainian legislation. Parties to cases may use the e-court to submit complaints before the High Council of Justice. It is envisaged to facilitate interoperability between the electronic court subsystem and the automated enforcement case management system, so that the reads of execution could be sent from the e-court subsystem to enforcement officers using a respective automated system for enforcement case management system. Files containing audio and video records of trials are available through the e-court subsystem. The judges may participate in court hearings via video conference using their e-cabinets and the e-court subsystem. Basically, cabinets of various types of users within the e-court subsystem are very similar. Among the most recent novelties is the creation of the cabinet of the High Council of Justice member. So now the members of the High Council of Justice may use their cabinets to deal with pending cases, to check the demographic register, to check information in the demographic register, and to exchange documents with the parties concerned. Interaction with the National Register of Defense Lawyers has also been established in order to make sure that respective lawyer still has his or her license and is in the position to practice law. The lawyers may receive electronic powers of attorney from their clients using the subsystem, the e-court subsystem. Besides, once a lawyer is appointed to a case, and once such a lawyer receives access to case files in a particular case, the e-court subsystem sends a respective notification to a judge who is considering the case. Besides, the e-court subsystem is interoperable with DIA system. In terms of notifying DIA users about date and time of court trials, and in terms of sending final court documents to the DIA profile of a respective user.
They provide these consultations both to participants of the cases, courts, judges, etc. Next slide, please. Then let's see what is planned. Yes. As of now, we have in our plans expansion of functional capacities of the user area. In particular, we planned, but it's still at the stage of implementation, but still we need to have some legislative agreements, some adoption of regulations that will subsequently provide an opportunity both to judges and members of the ACJ to use their accounts to request information from the Unified Register of Vehicles and the State Register of Property Rights to Real Estate Property. Among other things, we are right now processing the mechanism of judges issuing powers of attorney to review their accounts, which is very topical for judges' assistants. We also plan to introduce the calendar of court hearings as well as the user accounts of the prosecutor and investigator. Next slide, please. The subsystem of video conference. This subsystem right now provides participants of the case with an opportunity to participate in court hearings remotely using video conference outside of the court premises using their own digital means. In particular, it is possible to use the video conference module not only outside of the premises of the court, but also in the premises of some other court or the penitentiary institution or the healthcare facility as well. As of now, the subsystem of video conference has some functional capacities. I will not voice all of them because we have lots of them. Let's focus on the most important ones. This includes, first of all, that yes, it allows conducting court hearings in the video conference mode. Secondly, the subsystem of video conference provides technical recording of court hearings, both audio and video recordings. It also ensures print-out review of the minutes of the court hearing, as well as their preservation at the server. It also forms automatic links to the recording of the court hearing, which in particular saves funds from the budget because of the absence of the need to record hearings using some optical means. It also provides an opportunity to broadcast court hearings at the web portal if we are talking about some high-profile cases. The module of video conference can also be used to organize meetings, general assemblies of judges, because it allows to simultaneously show up to 30 participants of the video conference. But if we are talking about the meeting, for example, it allows to connect over 80 participants to this meeting at the same time. Besides, the video conference is completely integrated into the e-court now, so all users of the e-court have an opportunity to use their own user accounts to participate in the court hearing in the video conference mode using this particular module of the system. Basically, it has lots of other functional additional capacities. For example, that it is not possible to repeatedly sign the minutes of the court hearing, and that the recording shows milliseconds. Next slide, please, in order not to take too much time. As of now, the subsystem of video conference has over 80,000 users registered, and we have held over 300,000 video conferences.
Next slide, please.
Дякую.
Yes, thank you. And next slide now, please.
Також ДСА України
We also have plans in the SGA in the near future to introduce in the module of video conference a new system of booking courtrooms. We also plan to develop and introduce a mechanism of voice and image distortion during questioning of witnesses, for example. We also plan to integrate an automated opportunity of information retrieval required for a transcript from the parties of the court hearing using the number of the court case, for example, the party, etc., etc. And we also plan to introduce an improved voting system and the opportunity to sign the minutes by all participants immediately after the end of the voting, which is especially topical during the conduct of the meetings of the judges, because according to the law on the judiciary and status of judges, judges have an opportunity to hold their meetings remotely and to vote remotely as well, but there may happen open and secret voting. And if we are talking about secret voting, then for this purpose, we plan to improve the currently used voting system in the module of video conference. Next slide, please. Besides, in addition to the three subsystems that we have in the system of USAID, which ensure prompt access to justice, I would like to point out that we also have some other services functioning at our web portal, which ensure swift access to information, that is the Unified State Register of Court Decision, Contact Center of the Judiciary of Ukraine, progress of court cases consideration, where you can see information about the progress of consideration, information about the parties to the case, etc. And the list of court cases appointed for consideration, that is those cases which are roughly speaking showed in the calendar of court hearings, where we have all information about the court, judges, subject matter of the dispute, parties to the case, etc. As of now, these are the key electronic services which ensure prompt access to information about the case, and in turn, introduction of these services ensures a saving of budget funds as well. Yes, thank you. I see a hand raised, right? Yes, yes. Kostanko, Yevhen, I'm working with the e-court since about 2002, when they were adopting the law on the EU seats, and the SGA knows me quite well. I'm in touch with them. I would like to comment on your statements. Right now, you're telling us that you are introducing the video conference mode. I've managed to make sure that we can do that, but right now I would like to ask you to explain why we can't access the video conference mode through the judges card that are automatically introduced. You are against that, even though for the software developer that takes 10 minutes. Secondly, as the HGA, you do not want to comply with the requirement of the law and to connect all the parties that are obliged to be connected to the USAID. Regardless of my numerous applications to your managers, you refuse to publish the list of those persons who have to be joined there. You have to get it from the Unified Register of Attorneys, etc., etc. You have to get information about all the persons who have to be connected. You've responded to me that you are right now checking certificates, but you are not doing that. Right now, you have to comply with the requirement with the law. For example, according to the CPC, that is Article 45, and that is the requirement that you have to check the presence of the person in the USAID. If you've transferred your activities, you would have received a copy of the digital certificate, which has to be introduced by every attorney into the case, and it takes up to 1 megabyte of information. Thirdly, you do not allow IP for the connection information and to ask money for that, and that is required for police, prosecutor's office, etc. Then, in USAID, you are right now talking that you have 170,000 registered there, but I've been telling you for a long time, let's mail.gov.ua, let's use it, and once they have to access USAID, they have to do that either through mail.gov.ua, and they will be automatically registered then. Then you're talking about audio and video files. So you cannot connect all the audio file formats. So then you've limited access to video in an illegal way, because according to the law and according to the CPC, and you do not have the right to ask money for familiarization with any video recordings and with any electronic forms. In this case, you are not providing opportunity to see the materials of the court proceeding, that is the video file. Then you do not receive actually right now the electronic documents through the UCITS exclusively, even though that is regulation 1625 and requires that, and it is also required by clause 26 of transitional provisions of the CPC regarding investigators, prosecutors' offices, and prosecutors and detectives. You get these documents through the email. You do not check the CAPA existence. Moreover, it is not set out by the SGA's documents. As a result, I'm talking about that all the time, but you do not want to change that. And as a result, documents get to the court in abnormal form, and your employees do not ensure correct execution of these documents. And right now we can see from the statistics that 80% of documents in the paper form are absent from the UC, even in the case if they have been provided in the electronic form. I'm sorry, Evgen. We are really grateful for your comments. If you've heard at the very beginning of the event, for questions and answers, we will have allocated session at the very end. So sorry for interrupting you. We are grateful to you, but let's go back to that. Okay, I will disconnect in a second, but if they are right now telling you this information from the SGA that you've just received is not accurate, and in this case, she either explains that because it is not a question to general presentation. It is, I've looked through the list of people who will be speakers today, and thanks to you looking through their biographies, I can tell you at once that they basically will not tell us if we do not mention all of these comments. Thank you. Thank you, Yevhen. We have limited time. Miss Victoria, if you can briefly respond to these comments, please do that now. If not, let's postpone it till the very end because we have lots of speakers today.
Exactly.
So that's why we have to move on. Sorry. We can't hear you, Miss Victoria. I'm saying that, first of all, Mr. Yevhen, not she, but Victoria, at the very least, because I introduced myself when I was starting my presentation. Secondly, what I've just voiced is accurate, and what you've said, I've mentioned that we plan to partially take into account your suggestions. Partially, we've responded to you that this is not a priority for us. We have more priority tasks right now. Then, furthermore, if we are talking about prosecutors, investigators, we should not say that the SGA is the only institution to blame, because we also have the Office of the Prosecutor General, which also develops policy and obliges its prosecutors. At least it has to oblige its prosecutors to register in their accounts. Besides, thanks to joint efforts of the SGA and the Committee of Legal Policy, as of now, we have the draft law which at least will make public authorities to register in the e-court, because those materials of court cases and those materials that they will send to courts, and the court will see that this public authority has to be registered in the e-court, they will not consider these cases. Do you understand that? The SGA does not have any leverages how to influence public authorities, prosecutors, investigators, detectives, and other subjects with power authorities which are obliged to register in the UCITS. We cannot influence them. We cannot make them do that because there are requirements of the law, and as law-abiding citizens, they have to comply with them. If they do not do that, that is not our responsibility. We cannot bring them to administrative responsibility or any other responsibility, and we cannot influence them in any other way. But we do everything possible, and we are grateful to all of your suggestions that you are sending to us regularly. We read everything, we take it all into account together with our state-owned enterprises, and we work on them. But we implement them step by step because we can think a lot. But given that we have the lack of personnel, given that we have the martial law right now, it is all being implemented according to the priority order. Thank you, Ms. Victoria. Mr. Yevhen, thank you as well. I suggest Mr. Palma to move on to the next speaker and then to continue our discussion at the end with other participants. Thank you.
Thank you very much, Mrs. Prokorenko, for providing such a clear and profound presentation and for your thorough and practical description of the e-court security requirements and various existing and new functionalities, all of them aim to facilitate and improve access to justice. This including witness protection and enforcement, particularly sensitive areas yet to be developed in so many countries. Interaction with lawyers is also key to expand the achievement of such a crucial goal, something that, again, becomes essential to develop and improve worldwide. With regards to any potential new intervention, we'll have time for Q&A, so we appreciate if you communicate that using the chat box. Thank you. Please, Mr. Sergei Sushenko, legal advisor of USAID Justice for All activity.
Thank you, Dr. Palma. Дякую, шановний докторе Пальма.
Thank you, Dr. Palma. Right now, I will try to share my screen. Can you see my presentation now? Yes, great. Great. Thank you. Dear colleagues, Victoria has started saying about the systems that we have right now. And now, at the very beginning of my welcoming words, I would like to mention that as of now, digital technologies in course, that is the sphere where we have a huge potential for development, which has not been used yet, and which we should use, of course. But we have a question, how to assess what we have to expect from the e-courts and systems. There are lots of discussions, for example, right now about the sphere of artificial intelligence. So we have expectations in connection with that. Quite often these expectations are too high. Sometimes it happens on the contrary, that these expectations are too low. And in order to determine how necessary digital technologies are, there are some methodologies which allow assessing how effective it can be, how it can help with the court's work, etc. So therefore, our activity has carried out, in particular, the analysis of business processes in courts of all instances and jurisdictions except for the Supreme Court and in the SGJ. And I will tell you a little bit about the result of this business processes analysis, as well as about further perspectives for the development. What is a business process analysis when we are talking about the judiciary? Quite often we've heard this question because they were saying that we have processes, but we have no business. But actually, if we are talking roughly about that, business processes exist in any organization, in any sphere of life, and not only in commercial entities, but also in courts. And that is basically target-oriented activities structured in the form of consistent and logical actions. And these actions are performed step by step in order to achieve a specific expected result. How is the process approach used when we are talking about the description of activities? At the very beginning, we are analyzing input data, standard documents, KPIs. So we have interviews with employees, we have reporting gathered, collected about the effectiveness of their work. Then all of this information is being processed, and at the output, we get the summary process maps, step-by-step description of these processes with indication of bottlenecks and potential for improvements, as well as target models of processes, that is, to-be processes, which are the processes which are recommended for implementation. And right now, based on the example of the High Council of Justice, and I would like to point out that the figures that we will show are topical both for the HCJ and courts, basically, because the process of workflow in the HCJ has its peculiarities, but it's very similar to the process used in courts. So Our specialists have analyzed all of the processes. They have entered them into this table, and this table helps clarify not only which processes exist in the organization, but also to find out who is responsible for these processes, whether there are any overlaps in these responsibilities, and how we can determine the level of the process, whether it's high, medium, or low level, and how we can classify processes according to specific groups into administrative, auxiliary, and the main one. So, for example, if we look at the HCJ, then we will see that the lion's share is taken by administrative and auxiliary processes, while main processes in the activities of the HCJ take up 43%. Similarly, we have the situation in courts as well.
Ефективність цих процесів. Є декілька критеріїв, які можна використовувати.
There are several criteria which can be applied. In our opinion, it makes sense to use time and cost in the existing circumstances. And this is how we can measure efficiency. After having analyzed processes in the HAJ and in courts, some typical problems have been identified in key, auxiliary, and administrative processes, which are excessive workload linked to technicalities, overlapping, excessive paper document management in hard copies, some routine tasks, in great involvement of managers, excessive involvement of managers in the processes, and complicated internal communication. So these are the main problems which lead to lower efficiency and lower cost efficiency and greater expenses. Actually, the same applies to the situation in the HCJ. We concluded that the rules of procedure of the HCJ shall be reviewed in order to allow more effective delineation of powers and duties. And we also concluded that greater automation is needed. However, some problematic issues can be addressed without automation. For example, if some routine daily tasks are delegated to lower level professionals, it will allow to decrease the workload of medium and top management. Another easy solution, which does not require any automation, is the standardization of reporting documents. So it may seem that everything has been standardized so far, but our insight shows that there is more room for standardization. Now, we found out that automation, if once in place, allows saving some 50 or win some 50% in efficiency. This can be proved not only by our findings, but also by the experience and best practices of foreign countries. Speaking of Ukraine, there is a case management system in place, but it is quite outdated, and it allows automating only separate processes without enabling their interoperability. Thus, it is high time to implement a full-scale automated case management system. According to our calculations, once such a system is in place, some 20 to 25% of working hours can be actually saved and used for better with better efficiency, with greater efficiency. We also believe that automation can be also propagated to not only to administrative processes, but also to actually administration of justice and court processes, which are directly related to trial. Now, what is planned to be done in terms of automation of the judiciary? As you may know, currently, together with the EU Project Pravo-Justice, we have been holding the technical audit of all IT systems within the judiciary. Together with the EU project, we are also working on the development and deployment of a full-scale contemporary case management system. Besides, we will continue piloting online dispute resolution. We will continue contributing to the optimization of management structure in courts and use of IT tools for court administration. Our project continues providing support to courts which were affected by damages and losses inflicted by hostilities. As of today, we have provided PCs, software, data storages, 4G routers, and so on to various judicial institutions, especially those located in the territories located in the direct proximity to hostilities. This is it for now. Thank you very much for your attention, and I'm ready to answer your questions, if any, during the Q&A session. Thank you.
Thank you so much, Mr. Sushenko, for describing the functioning of these important services, particularly IT and automation, highlighting the necessity of achieving quality combined with efficiency in case management, of course, and all of the other ones. The following topic to be addressed is remote justice in the context of the ongoing war. Please, Mr. Tiana Panasiuk, head of the legal department of the State Judicial Administration of Ukraine.
Ну, я задав запитання, хотів.
Пане Євгене, ми ж, здається, домовилися, що запитання ми будемо за регламентом.
Sushenko, а ви можете розповісти, де у вас...
We will be glad to receive. Just to
please.
Excuse me. We'll have the opportunity to answer questions when all the speakers are done, are completed their ones, and then we'll have enough time for that. So we'd appreciate if you could wait for that till the end of each presentation of it by all the speakers. Thank you. Please. We'll get back to Ms. Panasiuk's presentation.
Так, всім доброго дня. Я рада вітати.
Good afternoon, dear participants.
Хотілося б подякувати міжнародній
I'm very grateful to the International Association for Court Administration, to the EU Project Pravo-Justice, and to the USAID Project Justice for All for having organized this conference. My name is Tatiana Apanasyuk. I'm head of the legal department of the State Judicial Administration of Ukraine. We are going to cover the topic of remote justice in wartime. Remote administration of justice is the inalienable part of the judicial reform. I guess this is of common knowledge, and this is something which is there and which will remain as one of our top priorities for the nearest future. Back in 2020, the law introducing amendments to some other legal and regulatory acts was adopted, and that law facilitated parties to court proceedings to submit documents remotely and to take part in trials remotely without being physically present in court premises using EasyCon system. The full-scale invasion has become the greatest challenge ever for Ukraine's judiciary. It required immediate response and fast decisions, because even under such complicated circumstances, the right to a fair trial cannot, and the right to access to justice cannot and shall not be limited. In this connection, in early March 2022, the Parliament voted the draft law allowing the participation in court trials remotely using any devices which facilitate participation in court hearings via video conference. It often happens nowadays that judges and parties to the case cannot be physically present in court premises because of air alerts or because of electricity cuts, which we had suffered through last winter. So in this connection, the Parliament even extended the possibilities of participation, of remote participation in court trials. However, it should be mentioned that the existing legislation allows remote participation in connection with the COVID-19 related restrictions. So it so happened that the pandemics coincided with the full-scale invasion, and that is why the wording of legislation allowing remote participation still refers to pandemics rather than war conditions. But here we are facing the problem because the quarantine related to pandemics is in place in Ukraine until June 30, 2023. So we need to get prepared to what happens next. The Parliamentary Committee for Legal Policy, which is responsible for digitalization of justice. In particular, there is a working group established under the committee. So the above-mentioned parliamentary committee is very active, and it has submitted a draft law before Parliament. They did it back in January 2023. So the said draft law contains provisions prolonging and expanding the possibilities of a remote participation in trials in connection with war time. The amendments suggested in the mentioned draft law are expected to stay in place once the law enters into force and until 90-day term after the end of war is over. So the draft law is still pending before Parliament. The State Judicial Administration has submitted its remarks to this draft law. The draft law is expected to be voted in the first reading shortly. Speaking of some key ideas of the draft law, they are the following: possibility for judges to have access to the automated case management system remotely, a possibility for the secretary of a trial to participate in a trial remotely. It also implies the possibility of replacing the secretary of a court hearing with judicial assistance, because currently there is a huge lack of secretaries of court hearings in courts in connection with the war. So women would live abroad. Many men would undergo military service in the armed forces of Ukraine, and some employees would dismiss because of low salaries. So the possibility of replacing secretaries is very topical. As Victoria mentioned today, the State Judicial Administration, supported by stakeholders and by interested individuals, will do everything possible to improve the existing e-systems and some subsystems, while also developing and introducing new ones. The administration of justice is ongoing in Ukraine despite complicated circumstances. The courts and the judges and the judicial government bodies adapt and do their best in order to comply with their duties in the best manner possible. I think that my colleagues will take over and share their experience as well. Thank you for now.
Thank you very much, Mr. Tiana Banasi, for presentation, including a crucial reference to the relevance of passing new laws to achieve and consolidate important ongoing and new developments. The normative component is sometimes essential, and you've made such a point eminently clear. Thank you. Please, Mr. Semen Krabtsov, attorney at law, PhD, national expert of the EU Project Pravo-Justice. The floor is yours, sir.
Доброго дня, шановні колеги. Радий бути присутнім на цьому заході.
Dear colleagues, my greetings to everybody. Unfortunately, we are as usually a bit behind the schedule because there are so many topics which would have been a topic for a separate conference. I will speak today about some methodological principles which need to be in place in order to introduce digital instruments in the judiciary.
Наук та адвокат.
And the attorney, please, next slide. Of course, when we are talking about remote justice, we can say that we are a bit late already. Of course, this lateness is not critical, but we should pay attention to the fact that we have been discussing in the professional academic circles about the need of introducing this institution. And in view of that, as well as given the pandemics and the war that is still ongoing in our country, as well as given the aggression of Russia that we are resisting right now, it is only becoming more and more relevant and more topical, even though, as we see, first of all, remote justice is absolutely integral mechanism in the difficult circumstances in which we are right now. Moreover, these circumstances are complicated for the entire country and not only for some part of our country, because it is equally dangerous everywhere. Of course, we can be talking about, when I was talking that we are a bit late, I meant that we had to respond, we both as experts and as legislators, first of all, we had to respond to this challenge in a corresponding way by introducing respective amendments into the legislation. But for some reason, it did not happen. So therefore, maybe we need to realize from the perspective of that it turns out that we have some time for that, we should not deal with troubleshooting because, of course, undeniably, as previous speakers have mentioned, justice and judiciary still are exercised even because of the, regardless of the lack of proper legislative regulation, but we have an opportunity to think where we have to consider and assess means for the improvement of the regulatory basis. And of course, undeniably, we cannot be saying that the remote justice is a response to a challenge. Personally, I encourage all of you as well, all the participants of any discussions to say that justice is the same form of justice as any other court hearing. We cannot say that remote justice is purely something different and something that is a response that can disappear. Moreover, in my personal opinion, and this is of course a very controversial idea, for example, the legislator does not think that if we look at transitional positions of the draft laws, and we can see that some provisions that are being introduced during the martial law have to be overturned or terminated after the end of the martial law in Ukraine. I, on the contrary, believe that these provisions are so timely that they should not be ignored, and that even now we have to look into the future in the context of how these provisions that are being introduced right now can serve as a good thing both for judges, for court operators, and participants of the proceedings in the context of exercise or administration of justice. Undeniably, the court, as it is quite popular to say, that is a service. That is not some institution only. That is not only the institution that deals with the performance of some specific functions of the state. The court means people, the court means service. And right now, any service in our life cannot be imagined without digitalization. So therefore, why should we deny that the remote justice has some other foundational principles and that has to be implemented only for a specific period of time? That's not so. Next slide, please. So this is what I've been mentioning at the very beginning of my presentation. Right now, we do not have the urgent need to ensure functioning of the judiciary during the martial law because it had to have happened much earlier if we are talking about the resolution of some specific issues as a quick response. On the contrary, we have an opportunity to focus our attention on how these provisions will be used not only during the martial law period, but also after the termination of the martial law. Next slide, please. Mr. Tana has pointed out already about some key draft laws, in particular, that is draft law 8358. I will not focus too much attention on any provisions in these draft laws. Basically, we have some of them. I've mentioned them as the main draft laws only because of the composition of authors and the legislative initiators. So I evaluate these draft laws as the draft laws that have high chances of being passed. But basically, we are talking about 8358 and 8359. And these are draft laws with respect to which the committee has recommended to adopt them in the first reading. And now next slide, please. We also have some other draft laws. These are government draft laws 1990, 1991, 9151, as well as this latter draft law 9151, which concerns the special mode of the court functioning. We have to be very careful with these draft laws in the context of the adoption after the draft law 8358. So there might be some overlaps in the regulatory framework. And it is quite obvious that everything depends whether this gap between the adoption take place, or maybe they will be combined somehow, and maybe some one draft law will be adopted as a result of that. Within the matter of our regional discussions, we discussed these draft laws, and we reached the conclusion that government's draft laws are wider, and are they to some extent cover even those aspects which are included into draft laws 8358, 8359. So that is why we should monitor their fate. Next slide, please. In order not to take too much time and to be able to pass the floor to the next speaker, I would like to express my ideas with respect to how we can ensure effective implementation of remote justice. First of all, not surprisingly, we are talking about the mindset. We have to be open to changes, and we have to ensure their prompt and planned implementation. Within the framework of our Pravo-Justice project, we pay much attention to changing approaches as a rule of participants to the proceeding, to the court as such. We are talking about functions of the court and judges, that it is not mandatory, for example, to be sort of, there is a popular opinion that parties come to the proceeding in order to control judges. Among other things, we are working on changing this mindset and destroying these specific stereotypes. And on the contrary, we encourage people participating in the proceeding to believe that changes are good, changes comply with the general European and international tendencies. Of course, in the context of what we are saying about a large number of draft laws and the way they are adopted, maybe we should change the approach to the legislative mechanism as well and to introduce amendments into the law in small packages. And of course, it can complicate application of legal mechanisms as well. But in any case, I think we should try out this approach, because otherwise we have the second year of the large-scale invasion, but the draft laws are still with the Verkhovna Rada. And unfortunately, of course, there is still time to adopt them, but it would be great if they would be adopted even last year. And maybe, for example, I can show you some European countries and the speed of their response to the COVID pandemics. Of course, during the martial law, this is very difficult to do that at once, but still sometime later, I think it would have been much more real to do that, because, for example, even in April or in the beginning of May, these possible amendments were developed. Besides, Sergei has mentioned analysis of business processes, and in my opinion, this is the key point in the sphere of digitalization and basically digitalization of the judiciary overall, because everything is based on business processes, on mechanisms, and we should monitor them, analyze them on a permanent basis, as well as involve not only people with experience of working directly in the legal sphere into these activities, but also external people who can provide this fresh perspective on the situation. Of course, cooperation with the private sector in terms of IT technologies and the important role of the expert community in the sphere of implementation of remote justice are quite critical as well, because the professional community raises these issues more and more often, and then we have more opportunities and higher chances that there would be a respective response to our suggestions and that they would be taken into account. And of course, undeniably, in the future, during the implementation of remote justice, when we will cross this psychological barrier, probably, where we have to fill in the legislative framework with relevant provisions, we can also think about the peculiarities of applying remote justice. And many European experts, for example, say that a remote consideration can be applied both as a mandatory process during minor disputes. Of course, right now this is an ambitious idea, but why not? Why don't we start this discussion right now? Because remote justice de facto exists right now, and even regardless of the fact that we do not have proper legislative basis that would allow to use available mechanisms and in line with regulations. Thank you for your attention very much, and I hope that all of you are more or less safe. And Dr. Palma, I'm passing the floor back to you, and thank you everyone for your attention.
Thank you so much, Mr. Kravtsov, for highlighting remote justice developments and achievements, stressing the regulatory phase and cultural change as key components of the whole modernization process. As you clearly said, almost any service cannot be imagined without digitalization looking into the future. Please, Mr. Andrew Rishenko, Judge at Dnipro District Administrative Court, Dnipro RJRC Coordinator and President of the NGO Genuine Ukraine. The floor is yours.
Thank you. Thank you, Mr. Lewis. If possible, please show my presentation right now. Yes, I will be very briefly telling you about what is happening and what was happening in the system of justice during the start of the large-scale invasion into our country. Maybe I will repeat some statements from previous speakers, but as of now, those legislative changes and amendments that we see basically fix and record the situation which already exists in the judiciary. So courts realizing their role in ensuring security and safety, realizing their obligation to ensure access to justice, to take care of employees of the court. Everyone has been fulfilling their functions and continue working. And in this respect, we would be really helped by quality digitalization of those services which we can use and which we use every day. But really, some problems we could prepare for these problems thanks to the 2 years of quarantine restrictions which we had in our country. And probably these quarantine restrictions will be over soon, but it has made us ready and our society ready that it is not mandatory to come to court in person, that you can send emails to the court, that you can participate in court hearings in the video conference mode. And on the 24th of February of last year, of 2022, the overwhelming majority of courts did not stop working, probably because they were administering justice in the remote mode. I can say about our Dnipropetrovsk district court, at least. We have analyzed a lot those issues that emerge with respect to digitalization of court services during the martial law period and the remote consideration of cases, and we've outlined 3 components. First component is probably the most important component, that is the security component for the consideration of cases. We all know that, unfortunately, courts are not provided with proper conditions to ensure security, and employees of the court, visitors of the court, and judges do not even have some basic means of like bomb shelters or something like that for protection. So we have instances when court buildings were hit by missiles, there were explosions in the courts, court employees were harmed. Unfortunately, we have such instances, and this is one of the key issues that has to be resolved. And maybe thanks to those changes and amendments that previous speakers have mentioned, for example, the opportunity of remote participation of employees of the court apparatus and judges in court hearings, but it does not resolve all the problems completely, because we still have some business processes which cannot be implemented without the presence of the person right now. Then the issue of access of people and participants of proceedings to the court premises. We have very different practices in different courts, and some courts, even during air raid alarms, they hold court hearings. In other courts, they hold nothing at all, and people are offered to move to the bomb shelter, but we do not have a unified approach regarding these issues. And again, I would say that the only solution to this situation is the increase in the number of those cases which are considered using the simplified procedure, using the written procedure, without the participation of the parties, only using materials of the case. And we really understand that it can be 100% coverage of all cases, but we need to increase the number of such cases in order to ensure safety and security of people, because if something happens to someone during the case consideration, that is a reputational loss for the judiciary and for courts, because they have failed to provide this security. Not even mentioning about merely the moral component of this instance. Then We also have the list of courts and participants to the proceedings, which are located on the temporarily occupied territories. According to the convention, in line with our constitution and our legislation, we still need to provide these people with a right to access to justice. At the same time, probably the only measure, especially when we see the escalation in hostilities, the only measure can be remote consideration of cases. And therefore, we overall support the respective initiatives with respect to the introduction of broader access to the electronic services. But next slide, please. In this respect, we need to focus on the following. In addition to these issues, we also have issues with respect to the second component, that is the procedural component, and it concerns how we can ensure consideration of cases in existing circumstances, that is during hostilities, when there is no opportunity to properly send summons to courts, etc. And even while working together with representatives of the Verkhovna Rada, we developed approaches as to how probably right now we need to say that summons to the parties should take place in any possible way. When we faced this issue, we proceeded based on several aspects.
Звучить він так: emergency break the law. Тобто у разі скрутної...
There is a very nice saying, emergency breaks the law, which means that once any emergency pops up, the law may be violated. We all live in the 21st century. We all know that the majority of people use various devices, including smartphones, which give them access to the internet. That is why, even in the absence of any specific regulation, many judges do use such devices. They send messages, they send emails in order to notify people about court trials, for example, in order to ensure effective participation of individuals in trials. We need to somehow streamline the issue of giving oath by witnesses remotely, I mean, because this is very topical, because as of today, witnesses cannot give evidence remotely. And because of this, many cases are pending. And this is related not to the complexity of such cases, but to the impossibility to proceed with trying such cases, especially under the existing circumstances where many people left Ukraine for abroad for security reasons. Besides, it has been mentioned today that the question of remote participation of judges and secretaries to court hearings remain in place. And it remains unanswered because there is the lack of proper regulation and proper practice. Next slide, please. What is also very important to be able to facilitate remote administration of justice is the technical aspect. which should be properly streamlined. As a practicing judge, I can state the following. Indeed, there is the e-cabinet in place, but the only thing a judge can do in the cabinet online is seeing the list of cases and seeing documents attached. There is no possibility to even somehow amend such documents or handle them in another manner. Besides, defense lawyers complain about the impossibility to use their e-cabinets for the purposes of proceedings. According to them, sometimes it is even problematic to get familiar with the case using the e-cabinet, or even less to make sure that other parties somehow prove that other parties to a case have got familiar with the case, which means that the functions, the toolkit of cabinet shall be expanded and customized according to user types. What else is important would be to facilitate interoperability between the judges' e-cabinet and opened registers so that I, as judge, could have access to the register to check or double check any information provided to me as a piece of evidence rather than make a person who submit evidence to provide hard copies of respective documents and to go and seek them in the first place. Besides having such an opportunity, I, as a practicing judge, could make sure that information I receive is free of any manipulation, is up to date, and thus I could make sure that evidence I'm dealing with is not distorted. Thank you very much for your attention. This is it from my side.
Thank you so much, Your Honor, for stressing such a key topic in order to preserve security with information and at the same time the safe use of technology. Now we'll start with the subject artificial intelligence and judicial systems, opportunities, benefits, and challenges. Please, Professor Ledger, Director of the Center for Legal and Core Technology, William & Mary Law School. The floor is yours, sir.
We are deeply honored to be with you today. I will spend about 15 minutes introducing ourselves and explaining the basics of artificial intelligence, better known as machine learning. My colleague, Professor Daniel Shin, will then speak specifically about the most recent developments, which is large language models, ChatGPT, and to some degree, despite the fact he's a great expert in the field, we have limited time, digital manipulation of evidence that are known as deep fakes. I apologize that our slides are going to be in English. And as you've heard, we are the Center for Legal and Court Technology, a joint initiative of our law school, the oldest in the US, and the National Center for State Courts. Our mission, our charge, is to improve the administration of justice through appropriate technology. And many of you will be familiar with pictures of our courtroom. This is what is called the McLaughlin courtroom. It is generally considered to be the world's most technologically advanced trial and appellate courtroom. And in part, I show that to you because of the discussion about remote justice, because I need to report to you that we now have the capability for life-size, three-dimensional remote holographic testimony, which is largely the same as having the human being physically in the courtroom. But that is not our topic for today. Our topic is artificial intelligence. Although, at least in the United States, there are a fair number of companies that are selling products for lawyers, legal practice, and the court world under the name of artificial intelligence, there are actually very, very few true artificial intelligence capabilities currently in use. As noted, Daniel Shin will talk about the most recent developments, which have both great potential and great risk. What are there that is actually available? At the moment, if you do not count artificial intelligence aided legal research for judges, lawyers, and others, perhaps the single most important AI-based court solution is in the area of what we call court record. AI-based speech to text automated transcript, which is now available from a company you may be familiar with called For the Record, FTR, although there are competing possibilities. I will note in the US, we do have federal government agencies, adjudicatory agencies that are using AI, but generally speaking, our courts are not really using AI as such. I would note that in China, there are significant reports of judges using AI to reach decisions. Although we have reviewed the original Chinese language reports, it is not clear exactly what is happening in China. So that brings us to the question of artificial intelligence. There are, if you will, two different definitions. The general definition, which unfortunately is not useful for our jurists, is this: the field that seeks technology capable of human-like reasoning, perception, and control. Or, put otherwise, technology that attempts to model and mirror human behavior. Under that definition, a great deal of technology counts as AI, but that is not really useful, and more importantly, it is misleading. True artificial intelligence is what we call machine learning. And machine learning is defined largely as a technology that modifies itself without human involvement. This may seem both strange and perhaps threatening. And indeed, depending upon your news coverage, I know you have many other things to worry about in Ukraine right now. In the last few weeks, we have had major commentators, often heads of technology companies, threaten the destruction of humanity if we do not adequately regulate artificial intelligence, machine learning. Of course, it's interesting that their regulation often seems to be a regulation that they themselves propose to create. But that's a matter for a different day. So I'm going to give you a very simplistic example of machine learning. It is adapted from a very real world example that took place in a gold mine where it saved an immense amount of money. And I realize this is trivial, particularly in Ukraine, where so many matters of so much greater importance exist. However, it's useful for our purposes. So let us assume that we have a courthouse. We have a chief judge who would like to encourage maximum productivity on the part of everyone in the courthouse. So the judge arranges to install an artificial intelligence system, a machine learning system, to handle the air temperature throughout the courthouse. They then place temperature sensors throughout the courthouse, and they start by adjusting the temperature to pick whatever your Celsius preference would be. I did 65 degrees Fahrenheit. Then, as time goes by, they go ahead and they monitor the productivity in the different parts of the courthouse. And as the AI determines that people are more or less productive depending upon the temperature of that part of the courthouse, the AI, without human involvement, modifies the temperature so that the people there will be most productive. Notice I do not say happiest, I say productive. And in that distinction is a long conversation potentially. Now, keep in mind that the system will have to be modified based, for instance, on holidays, based on birthdays. And therefore, the AI system modifies its programming so that in such a way that no one knows what the program will actually do, because no human being wrote the specific set of instructions then in effect. So that raises the question of how do we go ahead and create an artificial intelligence system? Human beings start by creating the program, the algorithm. Although Professor Shin will tell you that ChatGPT and other similar AI programs can also program as well. We then have to train this so it will do what it's supposed to do. The classic example here is, let us imagine we want to create a program that can look at a picture, can scan a picture of an animal and determine if it's a dog or a cat. In order for that to be done, we must show the AI system thousands and thousands of pictures of dogs and cats, and they have to be accurately labeled as dogs or cats, because if they are not accurately labeled, the machine will not be able to do its job properly. Then we go ahead and use the machine. And the machine determines what's a dog and what's a cat. If it makes mistakes and no one corrects it, it will malfunction. And indeed, one of the critical issues in AI systems is inadequate training, training with incorrect data, training with correct data that reflects conditions in the world that we do not want to continue with, such as racism. So one of the things that we can predict is that a machine learning system, one, cannot be adequately understood by a human being, because we can't look at the programming and determine how it actually works in a given case. And number two, we can predict with certainty that it is almost certainly going to malfunction at some point. We don't know when, how, or to what degree. From a court perspective, one of the critical problems is even if we could do all of this right, it is incredibly hard to find enough accurate court data that is usable to train an AI system. It is one of the critical problems in the experimental work now going on. Then imagine if we allow the AI system to gather information from the internet as it exists, along with all the false information on the internet. There have been real-world experiments that indicate exactly how badly an AI can function after exposure to that data. So why do we want to use machine learning? Because machine learning is incredibly good at detecting patterns and relationships between and among data. Given sufficient training, an AI system can predict what a judge is going to do, what arguments would motivate a judge to do. You might want to know that in France, it is illegal to use a judge's personal data for this purpose. So we are working on what is called explainable AI, so we can understand why an AI system reached a result, but that does not work well yet. So in theory, it would be possible to go ahead and use AI to determine a dispute, but right now, one, it is highly difficult to do so, and number two, we would not be able to explain why the AI reached that result. So, skipping over this, you might note in the area of legal practice, one of our huge banks, JP Morgan, is using artificial intelligence to review the legal accuracy of commercial loan agreements. It completes in seconds what used to take 360,000 hours of lawyer time over the course of a year. So we can also tell you that AI and very proficient lawyers can reach largely the same results, with the difference that the AI system does it in seconds and the lawyers do it in hours and days. So in short, AI is potentially of significant value to us all, but we are deeply concerned about the fact that machine learning not only cannot be fully understood, but we know that it will in fact malfunction occasionally. So much so that this past February, we had a symposium called Problematic Artificial Intelligence. We will have another such program in February of next year. Please consider yourselves invited. On that note, I yield to my colleague, Professor Shin.
Thank you so much, Professor Ledger, for your thorough and standing description of the essence of the subject that, as you once said in The Hague during a meeting I attended, has been among us for a very long time. The difference between machine learning and AI is paramount to know what is going on in this field, and he stresses it masterfully by providing a very useful example. While machine learning is excellent in detecting patterns, AI is increasingly important to increase quality, service, and productivity, but not happiness. Thank you so much again, sir. Please, Professor Dr. Daniel Shin, Cybersecurity Research at the Center for Legal Court and Technology at William & Mary Law School. The floor is yours, sir.
Thank you very much. Hi, everybody. Thank you very much for inviting us. We are honored to be here and presenting this discussion, these slides today. And also, thank you very much for the interpreters for your hard work right now. Today, I'll be just kind of briefly breezing through what I consider to be nefarious use of AI, especially on what we consider to be generative AI or AI systems whose primary purpose is to generate data based on data that it has been trained on. But before I dive into the main things, Professor Leder mentioned about ChatGPT, and I will just kind of briefly talk about ChatGPT for 1 minute. It is a type of an AI model called a large language model, whose purpose is to analyze large amounts of text. That includes Wikipedia, that includes one of the most popular social media, Reddit. And then the machine looks at patterns. It looks at patterns of how characters are formed, and then once it understands the concept of words and sentences, it looks at the greater pattern of how do you interact with human beings using conversational text. A few months ago, we actually had an incident where that is an ongoing problem, where an attorney at New York submitted a motion, basically a paper asking the court to act on something using ChatGPT. The problem was the ChatGPT is a storyteller that can either be talking about real world facts, but it can also talk about fictional stories. And by using ChatGPT, the attorney inadvertently cited to cases that didn't exist, but the formatting of the citation was correct. And so after submitting the motion, the court asked the attorney to produce these cases because nobody could find them. And unfortunately, the attorney decided it was a good idea to use ChatGPT to generate these fictional, non-existent cases. And right now, the attorney is facing very hefty potential sanctions for inadvertently, at least, deceiving the court. And so this is an example, a very recent example of a misuse of generative AI in the legal profession. But I'm glad that our previous speakers talked about case management and digital evidence, because the focus of my presentation will be on sort of the capabilities of generative AI in creating media that appears to be realistic, but is actually fake. The video that you see here, which might be choppy from your perspective, is not real. It was generated by some person on the internet using some of the AI technologies to create an advertisement for a beer commercial that is a little bit wacky. But although there is some sign that this is not a real realistic video, the point of this video is that we have technology that can generate realistic but fake media. This is an example. This is a screenshot from a Korean news coverage. As you know, there was a tragedy in Turkey and in Syria regarding the earthquake over there. And what happened was scammers used generative AI, specifically text to image AI systems, to generate this image below, which looks real, has a lot of details, photorealistic, but if you look closely on the fingers, you would notice that it is not 5 fingers, but potentially 6 fingers that this firefighter or the rescuer has. And this is actually one of the problems with some of the image generating AI systems. They're very bad at generating 5 fingers each. Granted, there may be people with 6 fingers for a rare medical condition, but scammers have already used generative AI to commit their frauds. Deep fakes is basically media that is synthesized or generated where likeness of a person, place, or concept is realistically but falsely created. And what deepfakes started to emerge back in 2018, but the problem is they are so good at generating realistic but fake media that, for example, this is the original video of a German news anchor just kind of doing the news. If I wanted to today replace his face with somebody else, I can use machine learning techniques to face swap or switch his face with another person. And afterwards, we have another video here.
Abends, meine Damen und Herren, ich begrüße Sie zur Tagesschau.
Of another person doing having the same facial expression realistically, but it's actually altered by artificial intelligence. Face swapping can also be done using machine learning in a live setting. So here is a video demonstration of somebody face swapping live using his computer. I actually did a demonstration 2 years ago where I did a live deep fake and took that AI generated image back to Zoom, which we're using right now. And so what does this mean? It means artificial intelligence can be used to not only generate media, but also generate live audio and video and transmit that into video conferencing software. And I'm not a technical person. I'm going to skip a couple of these demonstrations, but you can also generate fake voices as well. To show you how the technology has evolved in the generative AI space, these two images are not real, but they look really realistic. And we're at a point where image synthesis, video synthesis is a little bit behind, but image synthesis using AI is so way ahead that you can't distinguish them from a real photograph. So, and you can do add additional controls to adjust the AI generated images. For example, the picture on the left is a real photo of somebody doing a martial arts pose. And then I can take that pose and generate images of people doing the same type of pose. Some are humorous, but a lot of times they're realistic. And it calls into question of how do you handle digital evidence that may have been potentially generated using AI technology, because unless you have a life cycle, unless you have a way to track digital evidence at the moment of its creation, I think most of the, whether it's images, whether it's video footage, in the near future, there's a possibility that somebody may fabricate digital evidence. And this is something that is not uniquely to, I don't think, Ukrainian justice system, but that the US justice system is slowly but surely realizing the problem of AI technology. One last slide that I would like to show is AI is not necessarily a force that can disrupt the court system in a negative sense. It can also actually may potentially help the justice system. This is an example where if you have a blurry image of a person's face, there are ways to use AI technology to recreate or synthesize the face image to make it more clear. One note, this is not, this is adding new information to the blurry image that didn't exist before. So there might be some evidentiary issue, but if you have a blurry image of a suspect or a missing person, people can use these technologies to help facilitate investigations. So we're out of time here, but I hope this was quite helpful for everybody. Thank you very much.
Thank you so much, Professor Chen. ChatGPT is in everyday discussions, and it's really very important to know and to put it into context, as well as to do the same with AI, which is enormously important to understand. It's useful in our field, but the risk and terms in terms of stories and images, as well as regarding evidence, all of which can distort reality and jeopardize its use for the rest of the people. Now we have time to go to the Q&A. I want to stress that given some interventions were developed in writing, we will be happy to put the person in contact with SGI in order to address the various issues that were posed in writing. If we have any other comments or questions, please use the chat box and we will be happy to transmit them to the speakers. Thank you.
Dear Dr. Palma, I will just help to translate you from the chat. So we had a couple comments from Mr. Yevhen Kostenko. Most of them, as I see, were addressed in the beginning of this event by our SGA colleague, Victoria. So I suggest for Mr. Kostenko and SGA to continue the discussion later, because most of the comments were already addressed, and we encourage participants to put your questions in chat to other speakers. If you have, we have some couple of minutes left. So as of now, I don't see any questions from Ukrainian participants, except those that I mentioned before, but maybe people need some time.
We have some time until then, so we are okay with it.
Okay, I see, Dr. Palma, that we have one comment in the one question in the chat. I will say it in Ukrainian, and the translator will translate. Отже, у нас є запитання.
So we have a question from Ms. Katerina Brovka. Good afternoon. I'm interested in learning how the secretary of the court hearing can work remotely. I don't know to whom this question should be addressed, probably to our colleagues from the SGA. Maybe Mr. Rishchenko can add a few words about that. Please, you're welcome to answer that question. Who would like to answer this question? If possible, I could. I would like to explain that the issue of participation of the court hearing secretary, that was one of the red lines of the draft laws, which Kravtsov has mentioned and representative of the JA has mentioned as well. These are draft laws which are currently registered with the Verkhovna Rada. They really set out the opportunity for the secretary of the court hearing to participate in the case consideration remotely. So we meant only the procedural status as the secretary of the court hearing, that is to manage the minutes, not from the court premises, but from some other safe location. And in this respect, we provided our opinions and conclusions that, yes, really, on the one hand, this is just one of the functions performed by secretaries on a daily basis. At the same time, there is a list of job tasks which have to be performed physically in person, and we cannot move away from that. But this issue has been raised in such a way that we should provide an opportunity to court secretaries, but it faces the technical capacity of the USAID to provide for such participation. And secondly, I would like to mention again, as I've mentioned during my presentation, that existence of the electronic case and for the secretary of the court hearing, let's call it offline work, it will remove this part of work. So these are changes for the future. Actually, without the technical component, it will not work right now. Thank you. Thank you, Ms. Andriy. We also have questions to Ms. Victoria. If Ms. Victoria is still with us, I can't see her right now. We have the following question. Whether you plan the synchronization of the new mechanism of booking of video conferences with information at the web portal of the judiciary on appointed court hearings. It would be useful if the person who books a video conference would know whether the court hearing is appointed into the specific courtroom under a specific case. If Ms. Victoria with us, please answer that. Maybe not. Some of other speakers could respond to that. I can't see. Ms. Victoria is not with us anymore. With respect to whether the synchronization is planned, I'm not ready to answer for sure right now. I just see that Victoria is not with us and she is not picking up her phone. Maybe she had to leave. After all, the synchronization has to be undeniable because, of course, a person has to see, just like now. In order not to have this double booking, in order to have just so that we could ensure timely participation of the participant in the video conference mode, so that this person would know for sure that he or she can participate in this court hearing in a remote mode. Of course, if there is internet and something like that.
There's a comment, not a question, but a slight remark regarding text-to-image generation mentioned in Mr. Shin's presentation. Developers of Midjourney AI model used to generate these images, I assume, a fixed extra fingers problem. So it's a technical issue to take into account, a topic that deserves, of course, future consideration. Well, we are getting to the end of the session, so in order to finish it, I want to thank you so much for your excellent, thorough, and engaging presentations, which picture so vividly such remarkable developments and achievements on justice digitalization and information security management, as well as to continuously improve justice services at present times and far beyond. The description of ongoing and new developments, its benefits and risks were also a key part of the whole session, and they show us the challenges that judicial systems are facing to use them properly, and this way contribute to rule of law and social peace. Thank you all for being such a dynamic and committed audience. Soon we'll post on the IACA website the link to access to the conference recordings. We'll keep you informed about the date and time of the 5th and last online conference of the program dedicated to the integration of the gender approach policy in the judiciary. Please stay tuned. Looking forward to meeting with you soon again. Thank you all so much. Have a great day.